to talk about a fantastic and important subject today. Can patents block my research? We will talk about it through a very interesting story. Chapter 1. What do patents do? Well, a patent owner has the right to exclude everyone else from making and using a patented idea. Anyone that is making a product, selling a product, using a product without the authorization of the patent owner infringes that patent. However, there is no guarantee that under law that the patent owner can actually practice his own invention. So let's give an example of that. Imagine that you are doing drug research. You have an existing drug that is owned and patented by a third party, and you're using that drug and you come up with a new use of that drug. You can patent that new use, and you can prevent everyone else in the world from using the drug in accordance with your new use unless they get a license from you. However, as the patent holder of the new use, you yourself don't have the right to actually use that drug for the new use. Because the drug owner, you have to get the drug owner's permission to actually use the drug, and that drug owner has to get permission to market your new use of their drug. It's kind of a stalemate. Chapter 2. Can patents block my academic research? Well, the answer is absolutely, and the outcome can be rather unfortunate. So let's talk about that. There's this idea of something called a research exemption. So what is a research exemption? It's a very limited right under law to legally infringe somebody's patent. So what are these limited exceptions under this research exemption? Let's dig into that. Give you a couple of examples. Case number 1, if you're doing, for example, again, drug research, and you are using someone's patented drug or someone's medical device or diagnostic in experiments that are, quote, reasonably related to the development and submission of data to the FDA or some government agency, then you have the right to infringe that patent for that limited purpose, doing this research for the purpose of developing information that will be submitted to a government authority. So reasonably related is not terribly well defined under law, but it likely protects any type of clinical research and probably preclinical research, maybe doing a drug comparison study between your drug and someone else's drug that may be patented. So very narrow, though, nevertheless. Even more narrow. You can infringe somebody's patent. Another limited case is for a philosophical inquiry or curiosity, basically for amusement, to satisfy idle curiosity, or for strictly philosophical inquiry, so says the courts. I love that. So basically, you're hanging out on a Friday night and you read somebody's patent and you want to just test it to see if it works. And that's your philosophical inquiry. You can do that. You can actually test someone's patent to see if it works as advertised. However, excuse me, this defense does not protect any purpose that has a commercial intention, any furtherance of legitimate business purpose. So it's important to understand that a university's research activities to attract grants, to boost its stature and whatnot, are the legitimate business purposes of university, and they are not protected under the research exemption. Chapter 3, the free electron laser invention, a cautionary tale. So let's get into this story of Dr. John Mady, professor at Stanford University. He invented a novel microwave electron gun and a free electron laser, the FEL. Submitted this idea to Stanford's Tech Transfer Office. The Tech Transfer Office reviewed it, and although it was compelling science, they did not find it to be commercially relevant. And so they just turned the rights back to Dr. Mady. They said, we're not going to patent this. We're not going to try to commercialize it. You can have the rights back yourself. Well, he took them back, and he filed 2 patent applications and got 2 issued patents on his ideas with his free electron laser. Filed it in 1991, the patent issued in 1992. That is an extremely fast turnaround to get a patent. Dr. Mady's invention was very narrowly described in the patent. It was a very narrow patent, was not very broad, and therefore didn't get any fuss in the US Patent Office. But by today's standard, it takes 6-7 years to file a patent to issuance, and this happened in just about 13 months, very fast. So, moving along, Dr. Mady joined the faculty at Duke University, and his free electron laser laboratory at Stanford was moved to Carolina. In fact, Duke agreed as part of the bargain to build a new addition to their physics building to house the free electron laser and to develop his laboratory there. And for years, they had great success obtaining grants and doing research and creating new innovations using the free electron laser. It was a great time. However, that time, the grand period, the golden period, came to somewhat of an end. Mady was a questionable manager of the lab. Duke officials got more and more frustrated in his management of the laboratory, and in particular, they complained about him limiting access to the equipment to colleagues. It was meant to be a lab that was open to an entire center, a group of faculty, and he was hogging the darn equipment for himself. He contends, alternatively, that Duke's leadership wanted to use the equipment for unauthorized purposes, to research outside the scope of the government grants that supported the program. Now, that is not necessarily illegal or immoral. That happens a lot. But Mady thought that that was inappropriate, even though Duke would disagree with that. So what happened? Well, Duke got so frustrated that they appointed a co-director of the Free Electron Laser Lab, of course, over Mady's objections. Things did not get better. Eventually, Duke ended up replacing Dr. Mady as director, and they went so far as to petition the Office of Naval Research and other government agencies to replace Dr. Mady as the PI on these existing grants using the FEL. So Mady goes apoplectic, and he resigns from Duke, and he leaves them with the present on the way out. Chapter 4, Duke v. Mady, the lawsuit. Subsequent to his resignation, Duke continues to use the free electron laser. They're facilitating and carrying out their grant activities for the federal government, but they get served with a lawsuit. Dr. Mady sues Duke in federal court in the Middle District, Federal District for the Middle District of North Carolina. So sues him in court. And that lawsuit alleged many, many things, all kinds of stuff. Misappropriation of business opportunities, fraud, breach of contract, patent infringement. They threw the kitchen sink. The patent infringement suit actually got legs in the court and continued on. A lot of these other things were thrown out by the judge. But the patent infringement suit went forward. And so that claim stuck, and that was a subject of the court case. So Duke asserted in their defense in court that they're protected by the experimental use exception from the patent infringement. So they were not subject to any liabilities for patent infringement because they were protected by experimental use. So in applying this exception, the court looked at this and said, well, Dr. Mady, you have to prove beyond a reasonable doubt that Duke intended to commercially benefit from this research in carrying out these government grants. The court found that Mady's arguments were just hand-waving. They were just broad assertions. They were just speculation. They did not find his arguments compelling, and that they were inadequate to support a jury verdict in Mady's favor. So the court granted summary judgment. The jury did not hear the case, did not get to decide the case. The court granted a summary judgment to Duke. The case never even went to the jury. So Duke won the court case. However, as in many cases, Mady, he appealed this. So in the appeal went to the Court of Appeals for the Federal Circuit. The Court of Appeals for the Federal Circuit, it's a court that not many of us have not actually heard of before. It is the highest patent court in the country. They are specialized to hear patent cases. So they're one step below the Supreme Court for all patent cases. The Court of Appeals for the Federal Circuit looked at this, and they said that the lower court actually erred. They said that the burden of proving the exception, this experimental use exception, applies to Duke. It falls on Duke to prove in the affirmative that they can avail themselves of this exception. It does not fall on Dr. Mady to prove that it does not apply. So they further went on to say the experimental use is very narrowly construed, very strictly limited, and it is limited to performing actions for amusement, to satisfy idle curiosity, or for strictly philosophical inquiry. This is where I got that language earlier on in the talk from the actual court case. However, the Court of Appeals for the Federal Circuit kept on piling on Duke. They said that acts in furtherance of an alleged infringer's business do not qualify for this experimental use, and that Duke's research activities to further its Duke's research furthers its legitimate business objectives of educating students, of getting grants, of increasing its stature, things of that nature, luring students and faculty for recruiting purposes, that are legitimate business purposes of Duke, and that's being satisfied by carrying out these grants. So a not-for-profit is not sufficient status to avoid being accused and found liable of infringing a third party's patent. Just because we're a not-for-profit does not mean we can go around infringing people's patents. And that was the boom. That was the blow to Duke. Couldn't get around this. So what happened exactly? Well, the Court of Appeals for the Federal Circuit remanded the case back to the lower district court for additional proceedings that are consistent with the senior court's opinion. The ruling was appealed by Dr. Mady to the by Duke to the Supreme Court, and the Supreme Court looked at it and denied to take on the case. They did not grant certiorari. They did not hear the case. They felt that the lower court's ruling was correct. And so this was remanded to the district court to be retried in accordance with the CAFC's guidance on the matter. And they retried it, and they found in favor of Mady, no more appeals, end of story. There is no research exemptions that universities and other not-for-profits can take on to protect themselves from patent infringement. So coming back to this, Chapter 5, can patents block my research? Yeah, they really can. There's no safe haven for academic research activities. It's really risky business. It's the poor form to ignore patents. Steer clear of them if possible. If you find out that there's a patent-related issue, if someone brings it to your attention, please let us know about it. So thinking about it that way, there could potentially be a lot of infringing activities happening on university campuses all the time, perhaps every day, perhaps at Vanderbilt. Why don't we get sued for infringement? Well, there are a number of reasons why universities don't get sued, but to cut to the chase, the key reason is that to sue someone for patent infringement, you have to prove actual damages. You can only sue for actual damages. And university damages to a commercial entity are usually inconsequential. The university is not selling products or taking market share from companies, and so actual damages don't support suing someone for infringement. So we get away with it a lot at university campuses just because it's not commercially feasible to actually sue someone because there's very little to no actual damages. There are a few exceptions to that. There are some cases where there are, in fact, actual damages. If you can imagine that if I infringe somebody's patent, came up with an improvement, and patented that improvement myself, thereby blocking the patent owner from using the improved idea and therefore affecting their market share, they may very well sue us for that. Moving along, Chapter 6, can patents block my surgery? Well, unlike the previous answer, the short answer for this one is no. Medical practitioners, which are physicians, physician's assistants, nurses, medical organizations, everybody in the process of providing healthcare to patients are medical practitioners. There was a law passed in 1997. Congress did not want to limit access to medical care to American citizens, so they protected the providers of that care. A lot of countries don't allow you to patent medical procedures and things of that nature. You can protect them in the United States, but you really can't enforce them against physicians or any medical practitioner. So that's good. However, that includes medical activities, the performance of surgical procedures, things of that nature. It does not include inappropriately using third parties' patented devices or other products in the course of performing medical care or surgery or something of that nature. So we can be found of infringing someone's product patents. However, how do we get those product patents? We typically buy them. And so if you buy them, you're perfectly fine. If you read someone's patented or someone's publication and you made that device and put it in a human, which you never would do, if you did that, not only would you be breaking many other laws, you would also be potentially infringing that person's patent. So at the bottom, you can see physicians are protected from performing new suturing methods, for example, but not infringing a patent on the suture needle itself if it was a novel and patented suture needle. So one other thing I'll just cover very quickly is this concept of indirect infringement. If a company, perhaps a research sponsor, gave a physician or a medical practitioner a patented product of a third party to use in a procedure, the practitioner would probably is not really at risk of being sued, but indirectly, the person that provided you that product could be sued. So companies, it may not be your problem, but it could be the company's problem that provided you a third party's patented product if it was not legally acquired. Very rare, but happens on a couple of occasions. So moving on to the next, Chapter 7. Can patents block my research? Can Vanderbilt block my research? We have a lot of good blockers here in this particular picture. The short answer to that is probably going to be rather counterproductive for us to go around blocking our own researchers' research. So that's not what this is really about. What we're looking at here and what this question is really getting at is if you leave your job at Vanderbilt, if you go elsewhere, can we block you from doing research elsewhere? And the answer is probably we can. If you are doing the research and before you left, we patented some of your ideas and you continue to use those ideas elsewhere, you're infringing your own patent because your patent is owned by Vanderbilt, not by you personally. So something to think about. If you went to another academic institution, well, we would not assert any patent rights against you. We don't want to block that type of academic inquiry and whatnot. And they could probably do it to us if we're doing it to a third party. So you're in a safe haven if you've gone to another not-for-profit research institution. But if you've gone to a company and you are continuing to utilize patented technology for the benefit of the company, they need a license from your prior employer, from Vanderbilt in this particular case, including if you've gone to a startup company. Your startup company needs a license to continue to practice the patented inventions that were created at Vanderbilt. So a couple things to think about here. If you invent something at Vanderbilt, we cover this, Vanderbilt owns that. If you leave Vanderbilt and continue to use it, you may need a license. So nobody wants to cause any issues for sister institutions. People are changing employers all the time, blah, blah, blah. There are cases when it does make sense to request a research license. This is what I really want to get to. If you go to another academic institution and continue your research there, and you continue to innovate, those new ideas can be patented by your new employer. However, if your new employer tries to license them to a third party, the third party may say, well, wait a minute now, how are these inventions created? Were you actually infringing your prior employer's patents? So there may be some type of a taint on those new ideas if you don't have a license. So on occasion, we do give other universities research licenses to our inventions so that there's no question that they can invent off of them, advance those ideas, and then commercialize the results, as we all would like to do. So just wanted to point that out to you. That's what that's about. So going on, one more very interesting point. I already covered this. If you go to a startup company or a corporation, the company will need to license your technology. However, I wanted to make a note on this, something that everyone should know. If you do leave Vanderbilt and go elsewhere, we have some policies here. When Vanderbilt licenses your technology, we'll never come, if you're at another university or another not-for-profit, we're not going to come and sue you. But if we license your rights, your prior rights to a third party, to a company, they could actually come and try to prevent you from doing your research at your new university. And so when we license those rights to a third party, we exclude from the rights that we license to that third party the right to come and sue you. We retain the right to sue you with the expectation that we would never exercise that right to sue you elsewhere or sue your new employer. So licensing to a third party, these licensing activities, licensing of inventions, of innovations, will not disrupt your future research as long as you stay in the not-for-profit sector. So something important. Okay, let's wind this up with Chapter 8. Very quick, a couple of patent facts that I just always feel everyone should know to conclude this. Beautiful picture of a patented idea from 1882. A mousetrap, which is basically a gun shooting a mouse in the head. A couple things about patents. Patent applications take upwards of 2 months to draft, a month or two to draft by a competent attorney. However, a provisional patent, a temporary short-term patent application, can be done in a few days, same day if you actually need us to do so for an emergency situation. Even though they take a number of weeks to draft and file, patents take on average 5 to 7 years to issue from the time we first filed it. And the life of a patent is 20 years from the first filing. So I filed today, the patent issues 5 years from today, the patent lasts 20 years from today. Not 20 years from issuance, but 20 years from the first filing application. So how expensive are patents? Patents cost around $25,000 over that 5 to 7 year period. Half the money is in attorney's fees upfront to draft the patent application and file that application. The other half the money goes toward fighting with the patent office to get broad protection for your ideas. So around $25,000 plus or minus a few $1,000s in the United States. Very expensive outside the United States, and most of the rest of the world where we commercialize, Europe, Canada, Australia, Japan, costs another $225,000, $250,000 from start to finish to file and get patent protection in those countries as well. And EU is around 17 countries in Europe. Lastly, and something very, very important, disclosure of an idea before you start that patent process, before we file a first patent application, whether it's a provisional or a full patent application, that first filing, if you have disclosed the idea publicly before we filed that first application, you have forfeited at that time all of your non-US rights. You can never get them back. And you could be jeopardizing your US rights as well. What happens in the United States is you get a 1-year grace period to file your patent application. You can disclose it publicly, and within 1 year from that date of disclosure, if you file your patent application, you can get protection in the United States, but you have forfeited your non-US rights. And from a commercial perspective, only having US rights to offer, 25 years ago, that was often enough. Nowadays, you need international protection in many cases to properly commercialize an invention. To get industry interested, you need those markets to be available, and you need to have patents protecting your ideas in those markets. So, very important thing. Let us know before you publish something. In a matter of a day or two, we can file a patent application on the side to protect those ideas, at least for some period of time, just before you file a patent application, just before you go to a conference and publicly disclose your idea, giving a presentation or a poster presentation at a conference. Before you put on your website and make it available to the world, please let us know. That's all I have for you today. Thank you for your attention. I'll just mention that our next Lunch and Learn is on intellectual property. It will not be an ordinary boring talk on intellectual property. It'll be the essential elements of intellectual property, patents, copyrights, trademarks, trade secrets, things like that really scientists and inventors need to know. That'll be Tuesday, January 27th, 2026. Thank you very much.